I had mentioned that it is very clear that the present system of Section 34 has created more problems than it has solved. It is intended to bring in a simple system of arbitration and so on, but it has actually created more problems. There is a rigidity in 34 which has to be addressed, and that rigidity has been partly relieved by the legislature, by inserting 34(2)(a), which is an addition. 34(1) by itself may not address problems which one may face, the courts may face while dealing with domestic awards. So Lordship will appreciate that 34(1) and 2, 34(2) deal with international awards and domestic awards, that is ICAs and domestic awards. But 34(2)(a) deals only with a domestic award. And there, Lord, they say that you can set aside the award to the extent of patent illegality, which was not the ground for 34(1). For 34 ground, you got the fundamental policy of India, shocking the moral conscience, etc. Now, my Lord, the point I'm making is this. Today, my Lord, we need not go into what is the meaning of patent illegality, what is the meaning of fundamental policy. That is not the remit in my humble submission of this bench. I am putting, Lordship, please continue. Yes. Lordship, 34. But the point I'm making, Lordship sees 34.
But 34 is an additional ground. It's not really a ground which permits 34(2)(a) is an additional ground
for domestic arbitrations.
But it does not permit segregation or division of an award per se.
Yes. Therefore, Lordship is right. What your Lordship is referring to 34(2)(a)(4). It says that, yes, maybe that's what your Lordship is. But my humble submission is, the point we are making, and I think there cannot be an argument against that the power to set aside will necessarily include the power to partially set aside. That's a well-settled principle in our constitution. The larger power will include the lesser power. You can't say either you set aside everything or don't set aside. To give a practical example, we'll have to see the law as to how it applies in practice. Now, all of us who have done arbitrations at some time, it is, in a sense, something like a civil case where there is a claimant instead of a plaintiff, we call it a claimant. Then there is a counter. Issues are framed. Invariably, my experience is the issues are framed by the arbitrators. If there's a counter claim, they'll take it together and issues are framed. Now, the point I made last time, at the time when the bench rose, was take a hypothetical case where the arbitral tribunal frames, let us say, 7 issues. Based on the pleadings, they frame 7 issues. And out of 7 issues, let us further assume that 2 issues, if I may use the word, are infected with patent illegality. They are infected with patent illegality. Now your Lordships have to decide, in such a case, do I set aside the whole award because it doesn't say partly, or the court can say these 2 issues are severable. They are severable. They are on a standalone basis. And I need not relegate the parties on all 7 issues back to the tribunal just because 2 issues are infected with patent illegality. But my humble submission is, the word set aside can't be given such a rigid meaning as to make it inflexible and put it into a binary of a black or white. And once there is a patent illegality, the whole award goes. So my first request is, Lordship may see set aside, must necessarily include partially set aside, that must be given, power must be given to the court, and I would submit it is inherent in the court. That inherent power is there. Lord, I'll show Lordship a passage from Ashok Hurra and Rupa Hurra in a different context on curative, where Justice Kadri says, we can't, once we see a patent injustice, we can't be a silent spectator and fold our hands and say we can't do anything. You can do. Now, my Lord, on this partial setting aside, I don't think there can be much of a, in my humble submission, much of a problem, because if the court is faced with severability, then it can't be said that if it's 34-2, I will sever it, but if it is 34-2, I will not sever it. That will be an illogical answer. That if I'm a domestic award and I'm under 34-2, severability applies, but if I'm under 34-2A, a certain sense of rigidity comes in. That cannot be the answer. The larger, bigger problem on a day-to-day basis is this, Lord.
But there you are going on the assumption,
Yes,
that severability
is there.
is possible.
Yes, that's my first limb. What I'm saying is, Lordship will imagine a chart, patent illegality, severable, non-severable. If it is severable, then to the extent of severability, partially set aside the award. That is the first submission. Now the larger problem now comes in. Suppose there is a patent illegality. Now first division is severable patent illegality, non-severable patent illegality. Now I am coming to the second classification, sub-classification. There is patent illegality, and it is of two types. It's a curable patent illegality and a non-curable patent illegality. But in my final submission, I'll draw the chart and give it to you. But I wanted to make the chart after getting your Lordship's reactions and hearing the other side also. And I'll show with examples how this court, where the illegality is curable, they have not set it aside and sent it back. They have cured it here and now. So what do I mean by curable and non-curable? What I'm submitting is, if the patent illegality goes to the root of the matter, just imagine Lordship is now hearing an appeal from the High Court. Lordship finds the judgment has to be set aside. There is nothing else can be done but to set it aside. The judgment is so unsustainable that the court sets it aside. At the same time, my Lord, times innumerably, Lordship has partly allowed the appeal. Partly allowed the appeal. So my submission is, if the patent illegality is curable, why can't we say that the inherent power of the court includes the power to cure that illegality alone? And now if a Lordship reads the section carefully, 34, I want to make a submission that only if is not confining the powers of the court, the only if is a maintainability. If you just read it with me for 1 second, then I'll go to my last part. 34.1 and 34.2, Lordship will kindly see. 34.1 says, recourse to an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 or subsection 3. So that means that this setting aside can only be on the basis of an application. It can't be a suo motu. Now, an award may be set aside by the court only if the party making the application establishes on the record, it's been substituted for proof. So my humble submission is, actually an arbitral award may be set aside by the court. There are two grounds. That only if must be linked only to clause A. Lordship will appreciate, it should be linked only to clause A, because unless the applicant brings it within 1, 2, 3, 4, 5, the application will not be maintainable. Now come to B. The court finds that court finds that. So typically what we do in real life, in day-to-day is, in our 34 application, if the award is suffering from an infirmity under 34(2)(b), we also add that as a ground that the award is contrary to policy of India, or it's not capable of settlement under the law for the time being in force. That's not an arbitrable dispute. That we add it as a part of an application. But that is not necessary for the maintainability. What I'm submitting is, B indicates that there is an inherent power given to the court to address a case where the arbitral award is on a ground which is not capable of settlement. Suppose the party had not taken that ground at all. He satisfies 1, 2, 3, 4, 5. He doesn't take the ground that it is not capable of settlement. Like the Lordship has held, it's complete fraud, forgery, you can't go for arbitration. He takes that point. Or it's in conflict with public policy. That ground is not taken. Can a Lordship say that, no, I'm bound by the pleadings? No. Lordship will say, look, I see the award. I see it's non-arbitrable. I see it's contrary to public policy of India. Therefore, I can interfere and set it aside. There my submission is in 34(2)(b). Also, it is not all or nothing. If there are 4 disputes, 2 are not arbitrable, those 2 can be set aside. If the remaining 3 are arbitrable, let it go. Let it continue.
No, that's provided in clause 4 itself. So
no, but not in 2B.
Not in 2B.
Yes.
Now, the difficulty, there are 2 ways to interpret, though it's not strictly within our domain
yes.
or the reference. But if one looks at subsection 1,
yes.
the recourse to the court against an arbitral award can be only made on an application for setting aside of the award in accordance with subsection 2.
Yes.
Now, this will mean an application by a aggrieved party.
Yes.
But if we look at B, the court finds that, logically speaking, it says it will be only unless the party has taken recourse to an application in terms of subsection 1, the court finding will not be there.
Correct. The court can't see when award is come in the media, like I take under Article 2.
Or even if, say, executing court cannot.
Yeah, Lordship is right. At the Order 21 stage also, he can't say, no, it's contrary to public policy, therefore I'm. Because by that time it becomes final and binding.
Correct.
Yes. So what I'm arguing is. Sorry.
The court hearing a 34 is not a creature of this statute. It is a court which independently
exists. It's a 2E court.
With its inherent powers.
Yes.
Under the old act also, 151 has been invoked wherever statutory provisions were, found to be deficient. Probably Ramji Dayawala in context of 34.
Yes.
Additionally, 154 to stay the suit. So we will also ask them, would 151 CPC be available to the court, because we can't treat the court as a tribunal which is a creature of a statute.
Yes.
It is a court which exists with its